Okay, so Title 2 of Revised Penal Code of the Philippines, Book 2, under Article 124 to Article 133, Crimes Against the Fundamental Laws of the State. So we have Chapter 1, Arbitrary Detention or Expulsion, Violation of Dwelling, Prohibition, Interruption, and Dissolution of Peaceful Meetings, and Crimes Against Religious Worship. So Section 1, arbitrary detention and expulsion. So Article 124, arbitrary detention says that any public officer or employee who without legal grounds detain a person shall suffer first the penalty of arresto mayor in its maximum period to prison correctional in its minimum period if the detention has not exceeded 3 days, and two, the penalty of prison correctional in its minimum and maximum periods if the detention has continued more than 3 but not more than 15 days. 3. The penalty of prison mayor if the detention has continued for more than 15 days but not more than 6 months, and that of reclusion temporal if the detention shall have exceeded 6 months, and the commission of a crime or violent insanity or any other ailment requiring the compulsory confinement of the patient in a hospital shall be considered legal grounds for the detention of any person. So yun, minemorize. Minemorize ko talaga. Kasi, kasi ano um, iniisip ko kung i-memorize ko yung elements, so i-memorize ko ba yung articles. So, ayun, so minemorize ko lang yung article. Kaysa yung elements, parang isa-isa pa. Hindi ko alam kung, it depends Kasi sa akin, it works for me na i-memorize yung article kaysa i-memorize yung elements. Pero syempre, hindi naman pwedeng puro memorize. Ano memorize mo, intindihin mo din yung kahit hirap. Kahit hirap na hirap intindihin, try mo. Mga ganun. Okay, so for the elements. Kasi di ba, dagdag ko lang sorry na. Pagka kasi memorize mo yung article, nandun din yung elements eh. Di ba yung pag binasa mo yung isang buong article na yun, tapos balik ka sa elements. So, pansinin mo, nandun lang din siya. But you need to learn kasi may mga bagay na hindi masyado pansin pag binasa mo lang yung article. You really need to understand it. I know it's difficult for everyone. Wala naman talagang madaling journey. Pero gusto natin yan. So, taste ganda. Anyway, so for the elements, first, that the offender is a public officer or employee, that he detains another person. 3, that the detention is without legal grounds. See? Dahil minemorize ko siya, alam ko agad yung elements. So, yun. So, we need to remember that yung public officer na liable for arbitrary detention na tinutukoy sa Article 124 should be vested with authority for detention o to order a detention of a person accused of a crime. Kasi sino-sino ba yung mga public officer and employee? For example, teacher. Employee siya, di ba? Pero meron ba siyang authority to detain a person? Siyempre wala. So ngayon, pag siya yung nag-detain ng another person, hindi siya arbitrary detention, though siya ay employee or public officer. For example, basta wala silang grounds. Wala silang grounds at wala silang authority to detain. Sorry, hindi sa walang grounds. Wala sila totally authority to detain a person. It is illegal detention. Pero, for example, yung private individual na yon ay nag-conspired dun sa public officer in detaining another person, tapos meron siyang authority to detain a person, guilty sila for arbitrary detention. Pareho sila. Ayun, maidagdag ko lang dun sa teacher. Bakit siya illegal detention? Because they are already acting in their private capacity. Hindi naman niya ginawang detention under the position she hold or he holds. Okay. So, kailan nga ba may detention? Sabi, may detention daw pagka merong actual confinement of a person sa isang enclosed space o yung manner of detaining that it will deprive him of his liberty. What if, for example, yung tao na yun, wala sa loob ng kulungan. Nandun lang siya sa holding area. Tapos sabi nila di naman namin siya dinitain, kini-question lang namin siya, ganyan, ganyan, ganyan. Nasa holding area lang siya, okay. Hindi siya, okay, nandun lang siya sa isang area na yun. Detention pa rin ba yun? Siyempre, detention pa rin yun. Why? Though hindi siya nakakulong dun sa enclosed space na yun, yung manner of detaining him dun sa isang space na yun, sa isang lugar na yun, na hindi siya, sabihin mo nakakalakad-lakad siya, nakakapunta siya ng CR, detention ba yun? Yes, it's still detention. Why? Because kasi he don't have the freedom na umalis dun. Tinanggalan mo siya ng freedom na lumayas dun Sabi nga dun sa case ni People versus Flores, mayroong restraint. Pagka yung tao, hindi siya malayang umalis dun, tapos meron siyang takot na pag umalis siya, yari siya, that's detention. Okay. So, detention is without legal grounds when, one, he has not committed any crime, syempre, malamang. Or at least there's no reasonable ground for suspicion that he has committed a crime. Two, when he is not suffering from violent insanity or any other ailment requiring compulsory confinement in the hospital. So, to understand more about arbitrary detention of Article 124, we need to learn about warrantless arrest because in arrest without a warrant, it is the usual cause of arbitrary detention except for the three factors. One, when in his presence, naalala niyo ba yung in flagrante delicto, hot pursuit, tsaka escapee? Ito yun. So first, when in his presence, the person to be arrested has committed, is actually committing, or is attempting to commit an offense. Two, when an offense has in fact just been committed, and he has a probable cause to believe based on a personal knowledge of facts and circumstances that a person to be arrested has committed it. Ano ba yung example nito? For example, napanood ko to dun sa isang video ni Attorney Duca. So, gamitin na rin natin yung example niya. Yung example niya doon is like ganito. Meron isang babae, ikaw pulis ka, nakita mo yung babae, sumisigaw, sabi niya, snatcher, snatcher. And then, nakakita ka ng lalaki, humahagipis, tumatakbo. Tapos, may dalang shoulder bag. So, habulin mo ngayon yung tao. Kasi, you have the probable cause Parang pinagpasal-pasal mo, may babae, sumisigaw, snatcher, may tumatakbo, may dalang bag. Di naman usual na merong lalaki na madaling pouch, di ba? Yung mga ganun. Okay, the third, when a person to be arrested is a prisoner who, dalawa to, una, tumakas siya dun sa penal establishment niya o kung saan siya nagsiserve ng final judgment niya o kung saan siya temporary confined. Pangalawa, during transfer from one confinement to another. Yun yan. O next, Article 125, delay in the delivery of detained persons to the proper judicial authorities. So the penalties provided in the next preceding article shall be imposed upon the public officer or employee who shall detain any person for some legal ground and shall fail to deliver such person to the proper judicial authorities within the period of 12 hours for crimes or offenses punishable by light penalties or their equivalent, 18 hours for crimes or offenses punishable by correctional penalties or their equivalent, and 36 hours for crimes or offenses punishable by afflictive or capital penalties or their equivalent. In every case, the person detained shall be informed of the cause of his detention and shall be allowed upon his request to communicate and confer at any time with his attorney or counsel. Yun. So nga sabi ko sa inyo, pag memorize nyo, dali lang. Pero pag-usapan pa rin natin yung element. It doesn't matter if you memorize it or not. Kasi pagka naintindihan mo na siya, madali na rin, yan yung elements madali na rin i-push yung elements Yung elements naman, even on quizzes, on major exam, or even in mock bar, hindi naman kailangan kung ano yung pagkakasalaysay sa libro, yun din ang pagkakasulat nyo ng elements. No, it's not. In your own words, write the elements. Okay lang yun. As you remember, as you understood. Kasi nga, syempre, nag-aral kayo ng CRIM 2 o CRIM 1, 3 years pa bago kayo mag-par. So, kung minemorize nyo siya, tapos di nyo naman naiintindihan. Kung hindi minemorize natin, tapos di natin naiintindihan, puta, patay. Sorry. Patay tayo niyan susunod. Diba? You need to study again. It's better to study now, understand it, and then if you feel that you need to memorize, you memorize it. Okay, so for the elements, pagka binabasa mo yung elements, it's as if na binasa mo na rin yung article. So, it's the same. Okay, so 1, offender is a public official, public officer or employee. 2, that he has detained a person for some legal grounds. 3, that he fails to deliver such a person to the proper judicial authorities within 12 hours for crimes or offenses punishable by life penalties or their equivalent, or 18 hours for crimes or offenses punishable by correctional penalties or their equivalent. 36 hours for crimes or offenses punishable by afflictive or capital penalties or their equivalent. We need to remember that Article 125 in the delay of delivery, it is not applicable when the arrest is by virtue of a warrant of arrest. Right? So the delivery to the second is the delivery to the judicial authority of a person arrested without warrant by peace officer does not consist yung physical delivery ba, but the delivery means yung making of accusation, charges, filing of information against dun sa person that is arrested kung saan siya dapat na court. Ganun siya. Okay, so distinguish natin yung Article 125 sa Article 124 kasi medyo parang nakakalito siya ng konti. So, yung arbitrary detention under 124, yung detention doon, illegal na from the very beginning. Pero, kailangan natin tandaan na yung arbitrary detention, hindi siya applicable pagka yung tao nakadetain because of RA 9372, terrorism, di ba? So, I remember. Correct nyo na lang ako kung mali. Comment na lang. Okay, so arbitrary detention naman sa Article 125, ang siste dito, yung detention sa umpisa, legal. Ang illegality ng detention nag-i-start dun sa expiration ng period na in-specify natin kanina. Na-detain siya na hindi siya properly na-deliver dun sa judicial authority. Ganun. Okay, so Article 126, delaying release. So the penalties provided for in Article 124 shall be imposed upon any public officer or employee who delays for the period of time specified therein the performance of any judicial or executive order for the release of a prisoner or detention prisoner, or unduly delays the service of the notice of such order to said prisoner or the proceedings upon any petition for the liberation of such person. Okay, so act Spanish. 1, by delaying the performance of a judicial or executive order for the release of the prisoner. 2, by unduly delaying the service of the notice of such order to said prisoner. 3, by unduly delaying the proceedings upon any petition for the liberation of such person. So elements tayo. 1, that the offender is a public officer or employee. 2, that there is a judicial or executive order for the release of the person or detention prisoner, or that there is a proceeding upon the petition of the liberation of such person. 3, that the offender without good reason delays 1, the service of notice of such order to the prisoner. 2, the performance of such judicial or executive order for the release of the prisoner. Or 3, the proceedings upon a petition for the release of such person. So, usually dito, ang mga possible na mag-violate dito, wardens tsaka jailers. Kasi ito yung mga tao na for release na talaga eh. Yun, tapos may delay doon. Okay. So Article 127, expulsion. So the penalty of prison correctional shall be imposed upon any public officer or employee who, not being thereunto authorized by law, shall expel any person from the Philippine Islands or shall compel such a person to change his resident. Ano ba yung Spanish dito? Dalawa. Una, in-expel yung tao sa Pilipinas, pinalayas pa sa bansa, ganun. Pangalawa, pinilit siya na lumipat ng address. Wow. Ayun, so yung elements. Element is that offender, public officer or employee, two, that he expels any person from the Philippines or compels a person to change his residence. Third, that the offender is not authorized to do so by law. Bakit? Sino lang ba pwede magpalayas? Actually, hindi palayas. We know that there are cases in which the court, by final judgment, can order any person to change his residence. So we know this in the penalty of testiero. We can see this illustrated in ejectment proceedings, expropriation proceedings, mga ganang bagay. Okay, so section 2, violation of domicile. Article 128, the penalty of prison correctional in its minimum period shall be imposed upon any public officer or employee who, not being authorized by judicial order, shall enter any dwelling against the will of the owner thereof, search papers or other effects found therein without the previous consent of such owner, or having surreptitiously entered said dwelling and being required to leave the premises, shall refuse to do so. Okay. If the offense, so okay, qualifying circumstances tayo. So if the offense be committed in nighttime, okay, so yung qualifying circumstances, dalawa lang siya. Pag yung offense, meaning to say, naghalughog ka sa bahay na may bahay, nag-search ka doon ng gabi, tapos walang may-ari, tapos wala ding witness. Eh yun, qualifying circumstances yun. Tapos pangalawa, kumuha ka ng evidence. Yung mga kinuha mong evidence, hindi mo binalik agad. Ang penalty nun, prison correctional in its minimum and maximum period. So magbigay pa tayo ng example later on. So ano ba yung act Spanish dito? Sabi dito, yung mga pinaparusahan daw is una, pagka by entering any dwelling against the will of the owner thereof, or by searching papers or other effects found therein without the previous consent of such owner. 3, by refusing to leave the premises after having surreptitiously entered said dwelling and after having been required to leave the same. Ayun. So ano ba yung example nito? Okay. Tandaan niyo yung Act Spanish number 1 Number 1 and number 2 kasi meron tayong revelation after that. Okay, elements muna tayo before I explain further. So the elements, 1, that the offender is a public officer or employee. 2, that he is not authorized by judicial order. Meaning to say, wala siyang warrant of arrest to enter the dwelling and or to make search therein for papers and other effects. So, yung mga dapat nating tandaan dito, pag sinabing against the will of the owner, it presupposes opposition or pinagbawal talaga ng owner na wag siya pumasok. Okay. So ganito siya. For example, kasi 'di ba sa search natin, paano ko ba 'to i-explain? So yung customs and tariff yung customs and tariff, yun yung exception to the rule ng warrantless search. Pero, meron pa rin silang isang hindi binabiolate doon. Ang hindi nila binabiolate doon is yung pag-search ng dwelling o ng bahay. Yun. So ngayon, for example, ikaw, police officer ka, wala ka ng warrant of arrest, nag-search ka pa rin, ikakaiba na yun. Tapos wala yung ano doon, wala kang consent. Pero lagi nating tandaan, sabi dito, hindi crime yung ano hindi crime yung pag pumasok na walang consent. Pag pumasok na walang consent o may consent, walang crime doon. Ang crime, nag-i-start siya sa pumasok ka, tas nag-search ka. Tapos, nag-search ka, may kinuha ka pa. Kinuha kang evidence. Sabi mo evidence, tapos hindi mo pa sinasoli agad. Ay, illegal yun, kapatid. Okay. So, Article 129. Ito kaduktong to. Kasi, syempre nga naman, Section 2, violation of domicile. Naman magkaka-relate to mga to. Okay, so Article 129, your search warrants maliciously obtained and abused in the service of those legally obtained. So, in addition to the liability, nga pala, I forgot. Okay, so, di ba sabi ko doon ang qualifying circumstances natin? Una, paggabi. Pangalawa, pag may kinuha ka na ebidensya tapos di mo agad sinuli. Nga naman dito, sabi din dito, ito yung mga moments na kung saan pumasok siya. Sige, given. Okay, sige, pumasok na. Pumasok na, tapos di mo pinapayagan, wala kang consent. Pero, ayaw lumawas, ayaw lumayas. Pinapaalis mo na, ayaw pa rin lumayas. Yun yung violation na yun. Violation of domicile na yun. Okay, so balik tayo dun sa Balik tayo dun sa Article 129. Sabi dito, search warrants maliciously obtained and abused in the service of those legally obtained. So in addition to the liability attaching to the offender for the commission of any other offense, the penalty of arresto mayor in its maximum period to prison correctional in its minimum period and a fine not exceeding 200,000 pesos shall be imposed upon any public officer or employee who shall procure a search warrant without just cause, or hindi ko say probable cause, or having legally procured the same shall exceed his authority or use unnecessary severity in executing the same. Okay. So, acts punished by procuring a search warrant without just cause. Pero you say probable cause, it's just the same. Okay, by exceeding his authority or by using unnecessary severity in executing a search warrant procured. Ano ba yung sinasabi na unnecessary severity? If for example, meron nga siyang search warrant, tapos ang pagkakahalubhog naman niya ng bahay niyo, parang binaliktad niya na yung buong bahay niyo, yun, kakaiba yun. O kanyari, for example, ganito. For example, sabi, kunyari, meron nga siyang search warrant, kasi nga daw, sabi daw, yung bahay daw, ginagawang, parang prostitution din, for example, ganun. Ganun. Wala nga lang mali siya, gagi. Okay, so, for example, yun nga, prostitution din. Tapos, yung piggy bank mo, ayun, pinipilit nilang buksan. Tapos sabi nila, baka meron dong mga condom, chenelo. Ayun, severity yun. Nabasag yung nabasag yung piggy bank mo. Di ba severity yun? Mga ganun effects. Okay. So, elements of procuring a search warrant without just cause. Ano yung element nun? The offender is a public officer or employee. Again, he procures a search warrant. Third, that there is no probable cause or just cause. Okay. So, ano ba yung search warrant? Search warrant, yun yung written order galing sa judge under the name of the people of the Philippines. Directed siya sa peace officer na sinasabi niya, oh, ikaw, search mo tong personal property na to na nakadescribe dito. Tapos kung ano man yung makita mo na na-specify, dapat kasi specified yun eh, na-specify din sa search warrant. Dali mo ito sa court. Ganun. Okay, ano ba yung mga personal property to be seized? Subject of the offense. Subject of the offense, kung ano lang yung subject nilang dadalhin mo. Stolen or embezzled and other proceeds or fruits of the offense. So for example, ganito, sabi, drug din. So syempre may drugs. May drugs, may pera. Tapos lahat ng mga materyales doon, kunwari, tuter, pang scoop, kiluhan, mga ganun. Joke lang. Yung mga importanteng gamit, for example, laboratory siya, syempre, di ba? Pagawaan ng drugs, mga mga gamit-gamit na specifically used talaga dun sa paggawa ng drugs na important. Hindi ko lang sure kung kinukuha din yung kiluha na. I'm not sure about that. Siguro pag digital, kukunin. Hindi, joke lang. Okay, so, seryoso na nga tayo. Scholar, di tayo matututo pare-pareho nito. Okay, so elements of exceeding authority or using unnecessary severity and executing a search warrant legally procured. 1. That the offender is a public officer or employee. Nabasa ko na ba ito? That he has legally procured a search warrant. Ayun, that he exceeds his authority to use or uses unnecessary severity in executing the search, the same. For example, searching personal effects having a remote or no connection to the subject charged. O yun nga, sabi ko doon. Pangalawa, destroying furniture without justification. Yun nga yung example ko. For example, sabi doon, meron kang tinagong firearms. Sabi, marami ka daw firearms na hindi lisensyado. So ngayon, meron kang piggy bank. Ulit, may piggy bank ka. Medyo malaki yung piggy bank mo. Siguro, kasing laki ng, paano ba? Platito, ganun. Malita. Ayun. Mabigat. Sabi ng police. Titignan ko kung nandyan yung baril. Ang gano'n. Pinilit buksan, tapos nabasag. Yun. Remote. Wala siyang connection talaga. Possible ba na magkasya doon yung baril? Siguro bala, pero hindi rin bale. Kasi kung nakasid yung, kung nakasid yung piggy bank, tapos ang pwede mo lang ihulog is coin or yung buong pera, hindi magkakasya yung bala o yung basyo ng bala. Siguro yung powder ng bala, possible. I don't know. Okay. Basta, nasira yung furniture nang walang justification. Yun, bawal yun. Pasok yun sa elements. Okay, proceed, putik. Article 130, searching domicile without witnesses. Okay, so the penalty of arresto mayor in its medium and maximum periods. Siguro dapat basahin ka na maayos tsaka mabagal, no? Para maintindihan. Ayun nga, kasi sakit talaga yan pagka nabasa mo na yung ayan lang. Sobrang daming beses, tapos memorize mo pa. Ayun, so minsan hindi ko napapansin na ang bilis pala ng pagkakabanggit-banggit ko. Parang may lakad mamaya. Mga ganun. Kala mo naman sobrang busy. Anyway. Okay, so the penalty of arresto mayor in its medium and maximum periods shall be imposed upon a public officer or employee who, in cases where a search is proper, shall search the domicile, papers, or other belongings of any person in the absence of the latter, any member of his family, or in their default without the presence of two witnesses residing in the same locality. So what are the elements? That the offender is a public officer or employee, that he is armed with search warrant that is legally procured. Third, that he searches the domicile, papers, and other belongings of any person. Fourth, that the owner or any member of his family or two witnesses residing in the same locality are not present. So, Here in Article 130, everything is legal except for the last part. So after the search or before the search begin, kasi very important that there is witnesses. And syempre, there's people or the owner is present. So, ang weird naman nun, kung pupunta ka dun, magsa-search ka ng bahay, tapos walang may-ari, tapos walang witness. Parang bahay yun, di ba? Anyway, joke lang. Okay. Ito yung sinasabi ko kanina, yung exception ng Tariff and Customs Code. So, yung search without warrant under Customs Code, pwede siya. Pero, hindi pa rin kasama yung dwelling, yung house dwelling doon. So, bawal pa rin siya. Okay, Section 3 na tayo. Section 3, Prohibition, Interruption, and Dissolution of Peaceful Meetings. So, Article 131, the penalty of prison correctional in its minimum period shall be imposed upon any public officer or employee who without legal grounds shall prohibit or interrupt the holding of a peaceful meeting or shall dissolve the same. So the same penalty shall be imposed upon a public officer or employee who shall hinder any person from joining an unlawful association or from attending any of its meetings. So the same penalty shall be imposed upon any public officer or employee who shall prohibit or hinder any person from addressing either alone or together with others any petition to the authorities for the correction of abuses or redress of grievances. So what are the acts punished? So first, prohibiting or interrupting without legal grounds the holding of peaceful meeting or by dissolving the same. 2, you hinder any person from joining any lawful association or from attending any of its meeting. Third, you prohibit or you hinder any person from addressing either alone or together with others any petition to the authorities for the correction of abuses or redress of grievances. So yun nga, parang binasa mo na lang, parang inulit mo lang yung yung article. Anyway, so any elements. So that the offender is a public officer or employee. 2, that he performs any acts mentioned above. Only public. Okay, so always remember it's very easy and very simple. So here, on Article 131, ang pwede na mag-commit ng crime na to is public officer. Pangalawa, para ma-constitute na may violation dun sa paragraph 1 ng 131, dapat yung meeting, peaceful siya. Tapos, walang legal ground para ipagbawal o i-interrupt o i-dissolve yung meeting. Dapat sobrang lumanay nyo lang. Chill-chill lang dapat. Pero for example, the meeting is, for example, inciting to sedition or inciting to treason, mga ganon. Siyempre, the meeting should be interrupted and be dissolved. So, merong probable cause and merong legal grounds. Tama? Okay. So, isa pang dapat natin tandaan. Dapat yung offender dito na public officer, stranger siya. Hindi siya dapat participant nung peaceful meeting na. Hindi siya kumbaga gate crusher siya ba? Ang ganun. Okay. So, Section 4, Crimes Against Religious Worship. Konti na lang, dalawa na lang. Article 132, Interruption of Religious Worship. So the penalty of prison correctional in its minimum period shall be imposed upon any public officer or employee who shall prevent or disturb the ceremonies or manifestations of any religion. So if the crime shall have been committed with violence or threats, the penalty shall be prison correctional in its medium and maximum periods. So again, for the elements, yung offender, public officer, or employee. Pangalawa, merong religious ceremony o manifestation na nangyayari o ongoing. Pangatlo, yung offender, dinisturb niya o pinigil niya na mangyari yung ceremony na yun. Okay, so Article 133, offending their religious feelings. Okay, so the penalty of arrest of mayor in its maximum period to prison correctional in its minimum period shall be imposed upon anyone who, in a place devoted to religious worship or during the celebration of any religious ceremony, shall perform acts notoriously offensive to the feelings of the faithful. Yun. So yung elements that the acts complained of were performed, one, in a place devoted to religious worship, or two, during the celebration of any religious ceremony. Pangalawa, dapat yung act notoriously offensive to the feelings of the faithful. Ano ba yung mga dapat nating tandaan? Yung religious ceremony or religious act, yung mga performed outside of the church. Siyempre, ang hirap naman manggulo, di ba? Ang hirap naman mang-offend sa loob mismo ng church kung saan nandun yung Diyos, di ba? May mga picture ni Jesus, something. Ang hirap naman yun. Nasa labas ng church, tapos may procession, ang gulo ka, tapos inoffend mo yung mga nagdadasal. O kaya, yung mga nagdadasal, o kaya yung yung meeting na, ano ba tawag doon? Yung pagka may namatay, tapos dinadasalan na. Pag ginulo mo yun, grabe, no? Anong klaseng tao pa? Sobrang salba. Parang sobrang bad mo na nun. Oh, anyway, that is the end for Title 2 of Revised Penal Code of the Philippines Book 2. So this is just a refresher or additional knowledge for you guys. I'm not suggesting na don't read the book. Read the book kasi syempre, it's all in the book. This is just an additional, like a little spice for you to understand it more clearly. Pag kami mga bagay na parang hindi mo masyado maintindihan na malinaw, so minsan maganda meron din mga videos regarding that. Pero this is not a replacement of your book. Syempre, ang mamahal ng book nga din. So the book is there for you to read. I know it's painful and painstaking to read, but this is the profession. This is what we want. This is the reason why we are pushing ourselves to death, to sleepless nights, and to all the pain and sorrow. So, alam mo yun, gawin natin yung best natin. So anyway, guys, I'll see you for Title 3. I'll try to upload Title 1. I already have the audio. Actually, just to share quickly, I'm recording subjects like this not for other people actually. This is for myself, for my own review. Kasi yun yung way ko eh. It's my own way for me to learn, to remember things. Ginagawa ko whenever I read, I memorize, and I discuss it to myself. Pero ang weird naman. So, ang weird naman ako sabi mo sa sarili mo, oh, ito, yan. So syempre, you try to pretend that there is another person that you're talking to. Kasi sabi nga nila, it's one of the best way for you to learn is to teach it to other person. Yan. So I'm just trying to share. So this recording is actually for myself and for some of my classmates, for reviewer, for us. It is not intended to be shared, pero sige, share natin sa YouTube for us to able to help other students as well. Pero as I said, whatever I miss o kung may mga mali akong ni-note o may mali akong sinite, please comment below so that other listeners or other people who will check the video will see o para makita ko rin. And this is for the end time. This is not the replacement for your book. This is just for references. So that is all, folks. Go away and be gone. No, it's a joke. So I'll see you on the next video and have a wonderful day.